It's my honor to have the first lecture series after Justice Ravindra Bhatt has inaugurated the APCAM Lecture series. So this will be the first of the series, and every month we'll be having one session. The first of the lecture series will be on mediation case management for international disputes, and especially focusing on the APCAM rules, how we can do it under the APCAM rules. The entire purpose of case management is to make sure that the entire mediation, right from its initiation to the culmination of mediation, is done effectively through administered standards. After the Singapore Convention was made, we have to also make sure that the case management for an international or cross-border mediation should satisfy the requirement of the Singapore Convention. So the APCAM rules is basically meant to cover these two aspects. So if you're looking at the Singapore Convention, primarily, forget about all the articles in the Singapore Convention, but primarily there are two major issues in the Singapore Convention which specifies or make sure that how the enforcement of a mediated settlement agreement or an MSA can be refused. So primarily there are two major things. One is the deficiency in the process of mediation, and second one is the deficiency in the standard and the code of conduct of mediators. So primarily, if you look at the APCAM rules, the case management under the APCAM rules is made for effective, not only for the effective conduct of mediation, but also to make sure that the settlement agreement that arises out of the mediation is not refused and enforcement under the Singapore Convention. So under the APCAM rules, the case management guidance is given for both the institution which administers mediation and also for the mediator who conducts mediation. These two aspects, or the two pillars of mediation, are properly taken care of by the APCAM rules, right from the initiation of mediation to the starting of the process, to the taking you through the entire process until the conclusion of mediation, the guidance is given. So primarily the case management under APCAM makes sure that it cannot, if you're doing it perfectly under the case management guidance given under the APCAM rules, probably no court anywhere in the world can refuse the mediated settlement agreement that is made under the APCAM rules. So that is the case management structure that we have tried to make in the APCAM process. So if you look at the initiating of mediation, see, primarily a mediation is initiated by any party by giving a request for mediation to APCAM. And of course, the party can also give a request for mediation to the other side, so that once the request is made, see, one element that we have made very clear is, if there is no reply from the other side, or if the other party clearly indicates a refusal to mediate, then it will be treated as a refusal to mediate very clearly. But even if there is no reply from the other side, under the APCAM rules, you cannot proceed with mediation and it will be treated as a refusal to mediate. And this is a requirement under Article 5(1)(a) of the of the Singapore Convention, because under the Singapore Convention, a settlement agreement will be refused enforcement if a party was under any incapacity. So a party can always say that, see, he was not willing to mediate voluntarily, and the institution or the rules or the mediator forced them to continue with mediation. So a refusal to mediate is given due recognition under the APCAM rules. And once, see, there is again another step. Even if the party has already sent the request for mediation, APCAM will again send a request for or an invitation to mediate to the party under Rule 2.4, as I said earlier. And then a party who receives the mediation can either attend the mediation process, or he can notify his inability to attend on a particular day and ask for a rescheduling of the mediation process. Or if any party refuses or intimates the refusal to mediate, that also will be treated as a formal closure of mediation. And this makes sure that the mediation can never proceed without the express voluntary participation of the parties, which is a very important requirement under the Singapore Convention. And again, if the party does not nominate a mediator or fail to appoint a mediator, the APCAM shall appoint a mediator based on the requirement of the parties, and based on the convenience and the location of the parties, the mediator will be appointed. So under the APCAM rules, if you look at the case management process, normally there will be only one mediator unless the parties agree for co-mediation. And APCAM shall procure a disclosure statement from the mediator before his appointment under Rule 3.4. And this is very important, because the disclosure statement by the mediator makes sure that the mediator has no interest in the dispute or in the outcome of the dispute, or he has got any relationship with the parties with whom he is going to interact. And this is also a major requirement under the Singapore Convention, because under Article 5.1f, the enforcement will be refused if a party says that the mediator did not disclose circumstances which raise justifiable doubts. So this is also taken care under the APCAM rules under Rule 3.4. And if any party makes an objection to the proposed mediator within 3 days, the mediator shall not be appointed, and the APCAM will nominate a substituted mediator. Again, the same process of disclosure and the concurrence of the parties is taken. And if you look at the, because in APCAM there is a process, or there is a procedure called the ARB-MEDAB protocol, or the AMA clause. So under the AMA clause, the party will be going for arbitration, but after an emergency arbitrator is appointed under the APCAM arbitration rules, the arbitrator will stay the arbitration process and refer the parties to mediation. And that is under Rule 24.1. They can invoke mediation while they are going for arbitration, so that if there is a possibility of a resolution, amicable resolution, then they can complete the process. So this here, now if that was in fact at the time of initiating mediation, the case management, this was the role of APCAM. Now if you look at the role of the mediator, the guidance is given, because as we have seen earlier, before accepting an appointment by a mediator, he has to give a disclosure of any likely circumstances or any circumstances that can create a presumption of bias or prevent a prompt resolution of the dispute. Maybe suppose the mediator doesn't have the appropriate time to complete the process according to the APCAM rules. He have to disclose that. So under 3.4, this disclosure is mandatory. And as I said earlier, this is also a condition under the Singapore Convention, because if that disclosure is not properly given and the parties have come out with a resolution, and they suppose they say that this resolution, they would not have come to this resolution if the mediator had given a disclosure properly. So this is also a requirement under the Singapore Convention. So the case management makes sure that this is also complied with. And the mediator, as I said, the mediator also have to make sure that he can complete or she can complete the mediation within 90 days of his appointment. This is also a stipulation under Rule 6 of the APCAM rules. So in the disclosure, you have to make sure that you disclose your relationship with the parties, your interest in the process or in the dispute or its outcome, whether you have any financial interest or the outcome, whether you are known to the parties or to the lawyers of the parties. All these you have to disclose under the disclosure format. And you have also mentioned that you will have enough time to undertake the mediation of the parties, and you will be completing the entire process within a period of 90 days. So this is a mandatory disclosure under the case management process of APCAM rules. And if suppose that in any case the mediator, during the mediation process, the mediator was unable to complete it within 90 days, of course the rules takes care of an extension, and with the consent of the parties, they can go for a further period up to 4 months, but that should be with the written consent of the parties, and beyond that the mediator cannot take the process forward. And if you look at the next stage, where after initiation, how you start the mediation process, there also the proper guidance is given for case management under the APCAM rules. if you look at the role of APCAM, see the APCAM, after confirming the appointment of the mediator, then the APCAM shall work with the parties to establish the time and location of each mediation session, so that the parties' requirement, their convenience, and their express consent to participate in each session is taken care of by APCAM under Rule 5.1 of the APCAM rules. So, and in case like the COVID situation, or even a personal situation where the parties cannot attend physically, there is a provision under Rule 5.3f which says if the parties have any personal constraints, APCAM can arrange for virtual meeting. See, this is also a specific requirement or a specific condition made in the APCAM rules, because we have seen in many arbitration or mediation rules of institutions, under the rules there was no specific provision for going for a virtual meeting. But as we know, during the COVID period, many arbitrators and mediators used to conduct virtual meetings. See, but the problem is the parties can always at a later stage, they can say that they were not comfortable with the virtual meetings, and there was no express provision under their agreement to mediate or an agreement to arbitrate to go for virtual meetings, because they have only agreed for arbitrations and mediations to be conducted in physical meetings. So it was something that the arbitrator or the mediator have done beyond their express consent. So that is why that is also included in the APCAM rules, so that the parties have given an express consent to the institution that in case there is any difficulty for any party to attend, or they have any constraints to attend physically, the APCAM can arrange for virtual meetings. So there is an express consent of the parties. See, this is also a requirement under the Singapore Convention, because you cannot have the parties to be under some incapacity, and the virtual meetings should not take the parties to an incapacity. So that is also covered under this rule. And if you look at the APCAM rules as such, the entire APCAM rules, see, if there is any mediation clause in any contract which says that the dispute will be resolved by way of mediation under the APCAM rules, see, that simple clause will include a provision that the party can opt for an online mediation through a digital platform. So the APCAM dispute resolution clause by itself will take care of online mediation through a digital platform, because see, you will have to understand that there is a slight difference between mediation conducted in a virtual platform or a virtual mediation and an online mediation. Because in a virtual mediation, only the hearings are conducted virtually, but all the other filings, if there are submission papers or if the parties are submitting some position papers, all these are submitted physically, and only the meetings are done virtually. But under an online mediation, all the filings, all the communications, all the scheduling, everything is done online under a designated platform which is agreed by the parties. So that is also included under the APCAM rules. And another very important point is, under the online mediation, see, there are certain presumptions that are taken, because suppose the party is unable to log into the platform. See, whether it would be considered as a refusal to mediate or whether it will be considered as a technical problem. So under the APCAM rules, it's very clearly under Rule 23, the case management process, the guideline is given to the institution to consider in what manner a person's inability to join a virtual platform will be considered as a refusal to mediate, or whether it will be considered as a technical glitch which can be cured and they will continue mediation. So these type of security presumptions are also provided under the APCAM rules for effective case management. And if you look at the representation powers of the party, because in many institutions or many mediations, appearance by lawyers are sometimes prohibited, or in some cases there are strict conditions under which the lawyers or the third party assistants or the consultants can appear on behalf of the parties. But under the APCAM rules, very clearly under Rule 10.1, a provision is made where the parties can be represented or can ask for representation by any person of their choice. So whether it's a lawyer, whether it is a mediation consultant, or whether it is by their friends or whoever can assist them to do that, they can come. But here, one very clear stipulation is made under the APCAM rules for case management, because as we all know, that a mediation is a confidential process, and the parties are bound by confidentiality. But a third party or a non-party to a mediation, when he comes for mediation, he may not be bound by a confidentiality clause or a confidentiality condition. So APCAM rules have made it very clear that of course, this again, the choice of representation is also guided by the Singapore Convention. But under Rule 10.3, the APCAM rules stipulate that the non-parties will have to sign a declaration of confidentiality. So that means the lawyers or the consultants or any friends or experts who join the mediation on behalf of a party, they will also have to sign a declaration of confidentiality, saying that all that has happened or happening in the mediation session will be kept confidential, and they will not disclose it to any other forum, or they will not use it as a matter of evidence before any other forum, and they will maintain confidentiality of the entire process. So this is also a major requirement under the Singapore Convention, because this again, the party should not be put under any crisis of incapacity. And of course, whoever is going to appear in the mediation after they sign the declaration of confidentiality, such names, addresses, and emails of those parties and non-parties will be sent to all the other parties, like the mediator and to the opposite parties, to maintain the transparency and to make sure that no parties will make an objection to such experts or lawyers appearing in the mediation process. And this is also again a condition under the Singapore Convention, because under the Singapore Convention 5.1e stipulates that the mediator has followed, or the Mediation Institute for that matter, has followed the applicable process or the standards of mediation. Because if you look at 5.1e and 5.1f, a mediated settlement agreement can be refused enforcement if the mediator or there is a breach by the mediator of the standards applicable to mediation. So the standards applicable to mediation includes confidentiality. So suppose the mediator has entered a person, a non-party to the mediation process, without stipulating the confidentiality process, or without stipulating that the party abides by the confidentiality process, the party can raise a dispute that the mediator has breached the standards applicable to mediation. So that is why this Rule 10, 10.3 and 10.5 stipulates that the APCAM has to take into consideration under the case management process to get the confidentiality signed by non-parties as well. And of course, again, on the same issue, APCAM has to maintain that the mediation shall be conducted in confidence, and no transcript or formal record shall be made. Again, this also stipulates this is under Rule 11.5. Again, this also stipulates that the confidentiality of the process is maintained, and the condition of maintaining the standards of mediation under the stringent requirements of Singapore Convention is complied with. And again on incapacity, the APCAM shall, at the time of beginning of the process, because we are talking about the case management during the starting of mediation. So at the starting of mediation itself, APCAM shall inform the parties about the costs and expenses that will be incurred in the process. And because the APCAM, all the senders in all the 9 jurisdictions follow the same fee schedule. So there is no difference in fee schedule whether you are doing a mediation in India, you are doing it in Malaysia, you are doing it in Hong Kong or in Australia. The mediator and the mediation expense will be the same. So APCAM senders will inform the parties about the fee schedule applicable for administering the mediation and also for the mediator. And under normal circumstances, the APCAM will inform the parties that the expenses shall be borne equally. But suppose the one party refuses to share the expenses, then the other party can agree to share the entire expenses. That is up to the parties. But the APCAM shall inform the same and shall confirm about it before the commencement of mediation. So the case management makes sure that the parties understand the cost involved in mediation. So this is also again a requirement under the Singapore Convention, because the standards of mediation has to be made clear and the parties have to voluntarily participate in mediation, and there shall be no obligation for the parties to continue with mediation if they are not happy with the process. So that is also complied with under the APCAM rules. And if you look at the role of mediators before starting the mediation process, see, this is very, very crucial in a mediation in any cross-border mediation, because if you look at the role of mediator, mediator shall advise the parties about the relevant background and experience of the mediator, so that the party will know in what manner the mediator can help him, and if the parties have any objection, whether they are looking at any different experience or different qualifications or different expertise of the mediator, they can tell them at that time. So the mediator will have to explain that process, and more importantly, the mediator will have to tell the parties about the code of conduct they will be following. Because if you look at many cross-border mediations, different mediators will be following different code of conducts, because either they will be representing the institution or they will be applying the code of conduct made by some international organization like the IMI or the Institute. See, whichever organization has made the code of conduct, a mediator can adapt that code of conduct. But then the problem is the party will have to go through those code of conduct and understand what will be the norms and what will be the grade of code that the mediator will be following. But the stipulation under the...
So may I interrupt, sir? There is a question, sir, at this stage by Inan Gupta. She has raised her hand, sir.
Yes, Inan.
Yes, so my question was, can these rules be modified on a case-to-case basis? So for example, you talked about confidentiality, but in some instances, especially in like investor-state contexts, the parties may also have transparency obligations.
Yeah.
So in that case, can the rules of APCAM be modified on for this specific instance?
See, the confidentiality of the process is different from the transparency within the process, because within the process, that's why I said even when experts are appearing in a matter, see, it is made known to the other side, so the transparency within the process is maintained. The confidentiality is not within the mediation process or within the parties; it is outside the mediation process. So even in a mediation where the transparency has to be mandatorily maintained, that transparency is inter se the parties, and that provision is available under the APCAM rules, because inter se parties the transparency has to be maintained. The only case where the transparency is not maintained is when the parties are in caucus or in private sessions with the mediator, because whatever is said during the private session will not be disclosed to the other side under the insider confidentiality process. Because otherwise everything is transparent. Because see, even I'll be coming to that later when you conclude each session. The mediator is also bound to give a mediation report to APCAM, whatever has happened during that stage, because that mediation record will be available to the parties to show what was the process that was done during one session. So the mediation record form is also something that promotes transparency between the parties. So it is not confidentiality amongst the parties, but confidentiality outside the mediation room or outside to third parties. That is what that is stipulated under the APCAM rules. I hope it's clear.
Yes, and just to follow up for my clarity, what if one of the parties is a state? So they may have transparency obligations to the public, right? That because they can also that we are not compromising any state interests, we are keeping everything clear, and so that. So what in that case, when we have transparency obligations to the public, so in that case, how do you balance it against confidentiality?
No, see, normally only when there's an outcome in the mediation process. See, in such a what you call statutory transparency obligation is relevant, because suppose there is a discussion going on within a mediated session. And what is the process of negotiation that is happening between the parties, and what the other side has promised during mediation. See, that is not something that could be revealed outside, even under transparency obligations, because a state's obligation towards the public is to say that the outcome that we have arrived at during a mediation is based on particular standards. We have not compromised. So that obligation is a transparency obligation that the state has to the public when they come out with a resolution. But during the resolution, see, in no investor-state disputes or even for diplomatic mediations, such an obligation is not there to disclose what is happening within the mediation session, because that is confidential as far as the process is concerned. Only the outcome, once you comes out with an outcome, then why you have made such a resolution and what made you to make such a resolution, you may have to disclose to the public to make sure that it was a legally complied resolution that you have made. There is no underhand dealing, or there is no hidden agenda behind making this deal. So that obligation is totally different from the confidentiality within the process. Within the process, see, no mediation can function effectively unless you maintain the confidentiality within the process.
Understood, sir. That was exactly my question. Thank you.
Oh, okay. So the code of conduct that you follow is one key element that you have to disclose under the APCAM rules. And not only the code of conduct, what happens if a possibility of a violation of a code, if the party thinks that the mediator has not complied with the code of conduct, what is the process that the party can do if such a failure if the party feels that there's such a failure? Then that also has to be discussed with the parties at the time when you start the mediation process. This is mandatory under the APCAM rules when you start the mediation process. So that is also one of the case management process that the mediator has to understand while starting or commencing mediation. And this is of very high importance, because under the Singapore Convention, under Article 5(1)(e), an MSA will be refused enforcement if there is a serious breach of the mediator standards applicable to the mediator. Earlier I said about the mediation process, but here 5(1)(e) also stipulates that if the standards applicable to the mediator there is a breach in that, even then a mediated settlement agreement can be refused enforcement. So this is taken care under under Schedule 2(1)(b) of the APCAM rules, where the commencement of the mediation process, what role the mediator will have to take. This is clearly established. And another thing is under Schedule 2(3)(a), the mediator shall make sure that the parties clearly understand the role of the mediator, the process of mediation, and also the role of the parties and their advisors. See, what is the exact role of the mediator? See, whether he will be giving a resolution or he will be facilitating the parties for a resolution, and what will be the role of the parties in taking that decision, because ultimately the parties will have to take up the final decision, and what will be the role of the advisors of the parties. See, all these things have to be clearly discussed with the parties before commencing a mediation. This is also a case management requirement which is of high importance under the APCAM rules, because the parties should be very clearly knowing the process, that ultimately it is a voluntary process and the parties can walk out from the mediation room if they are not happy with the resolution, or if they are not happy with the mediator, or if they are not happy with the process. They can go out of the mediation because it is a totally voluntary process. So the power to withdraw from mediation and the power to take the final decision and the voluntary nature of participation should be highlighted to the party at the commencement by the mediator. This is a stringent requirement under the APCAM rules under Schedule 2(3)(a), which incidentally is also a requirement under the Singapore Convention. And to have a record of this, APCAM rules under Rule 3(5), it stipulates that after explaining the process of mediation and after telling them about the code of conduct they follow and all the stipulations which they need to understand throughout the mediation process about confidentiality, everything, then the mediator shall make an agreement to mediate under Rule 3(5), stipulating all these conditions, and they shall sign the agreement to mediate along with the parties, so that there is a clear record stipulating that the mediator have explained all these things to the parties, and the parties have agreed to follow the voluntary process on their own initiative. So this agreement to mediate is a strong document which shows that the parties were made to understand the process and the requirements and their respective roles, and also that they have the knowledge that they can walk out at any point of time. So this is a very stringent requirement under the Singapore Convention. And if there is a breach of the mediation process, and by this agreement to mediate, no court can say that there was a violation or there is a breach of the mediation standards or the mediator has violated the mediation process. So Rule 3.5 stipulates such an agreement. And this is another stipulation under the APCAM rules, because under the APCAM rules, the mediator, before the commencement of mediation, he can allow a pre-mediation conference with the parties or to allow a pre-mediation submissions, so that the parties know, or the parties can make the mediator understand what are the things that they need to resolve. So this memoranda or a position paper of the parties can be filed under Rule 5.3c, so that there is a clear understanding of the parties that what they want to resolve in this mediation, so that they are not they cannot say that I was confused as to what was the dispute that the parties were trying to resolve, or what the other side wanted to resolve. I was not very clear. That is why I've agreed for this settlement. So that cannot be made, because there is a provision under Rule 5.3c to make a mediation submission to the mediator, so that the process or the contents of the mediation or the substance of mediation is made known to the parties prior. And similarly, the mediator can also have a discussion with the counsels or the consultants or the advisors of the parties as to how the mediation should proceed, and a pre-mediation conference to have a discussion about the process and procedure of mediation, so that the consultants or the advisors of the parties know pretty well that how the process will be done and how the procedure will be manured by the mediator or by the institution. So this 5.3d makes sure that the process of mediation is made clear to the parties as well as their advisors, and they will have no confusion as to what they should be expecting from the mediation process. So this is again a requirement under the Singapore Convention, under the same 5.1e, where they can contend that the process or the standard, there is a serious breach of the standards of mediation. So this process is also explained as a second tier, because earlier there was an agreement to mediate which the mediator has made with the parties, stipulating all these things. This is a second tier of giving an information to the consultants that this is how the mediation will be conducted and the process will be taken forward. So this case management procedure, at the time of initiation of mediation and the starting of mediation, makes sure that the parties begin the mediation process clearly understanding the process, and none of the ground under the Singapore Convention for refusal is made available. And if you look at the process, the mediation process by itself, the mediator, if you look at the role of the mediator, under Rule 7.6 of the APCAM rules, it makes sure that the mediator shall facilitate a voluntary resolution of dispute and shall not impose any terms of settlement to the parties. So this is a very clear stipulation or a guideline for case management given to the mediator by APCAM rules, that they shall not impose any terms of settlement and it shall be a voluntary resolution process. And it also stipulates that the mediator, with the consent of the parties, can obtain the service of any experts who can assist the mediator or the parties in resolving the dispute. See, maybe a subject expert so that they can guide the mediator or the parties in coming out with a resolution. And again, as I said earlier, like a non-party, the expert will also have to sign a confidentiality agreement with the center, because when they enter into a mediation process as an expert, they will also have to sign the confidentiality agreement. See, these two things make sure that under the Singapore Convention, Article 2.3 says that a mediation should be with the assistance of a mediator who lacks the authority to impose a solution on the parties. So under the Singapore Convention, a mediation process will be a process by a third party who will not have an authority to impose a solution. So this rule makes sure, or it clearly gives an indication to the parties that this mediator will not impose a decision on the parties. So that also is covering the Singapore Convention requirement. And after every session of mediation under Rule 7.8, the mediator will have to give a mediation report, a record form to the center, and it shall be signed by the mediator and the authorized officer of APCAM Center, so that it will indicate the duration of mediation, how much time the mediation session was in progress, and which all parties had attended the mediation. See, this will be a record kept in the mediation center so that the parties can know clearly as to how much time they have spent in the mediation process. So there will be a transparency as to the time spent in mediation, so that ultimately, because if you look at the mediator's fee or the administrative fee, it is based on the time spent or on sessions. So there's a clear calculation available in the center with the record form that how much time they have spent in mediation. So if you look at the three stages of initiation, commencement, or starting the process, or the mediation proceedings, the case management procedure under the APCAM rules make sure that the participation of the parties in mediation is voluntary and they are not in any incapacity, and that the mediator and the mediation process is done under the strict regulations of the Singapore guidelines. And if you look at the conclusion or the conclusion of mediation, again, if you look at the role of the mediator, when the mediator finds that there exists an element of settlement, she shall formulate the terms into a possible settlement agreement and submit to the parties for their observation. See, this is a stipulation under Rule 12.1, which again comes back under Article 2.3, which says it is not the mediator who is making the settlement. The mediator is only making draft terms and submitting it to the parties for their observation. So the final authority to come to the resolution will be the parties, and the decision maker will be the parties themselves. And of course, the making of the settlement agreement, once they reach the agreement and once they confirm the settlement, the mediator, with the assistance of APCAM, may draw up the MSA on the terms agreed by the parties. See, this again, the role of APCAM is to make sure that the format of the settlement agreement is clear, and it is of course APCAM has got a format of a mediated settlement agreement to make sure that the settlement agreement goes through the rigid formality of the Singapore Convention and will be enforceable anywhere in the world. So these requirements are also taken care by APCAM, and under Rule 12.2, the parties will have to sign the mediated settlement agreement, and the mediator shall authenticate the agreement and submit the same to the parties. A copy is furnished to the parties under Rule 12.2. And this again is a requirement under the Singapore Convention, because Article 4.1a and b stipulates that the MSA shall be signed by the parties and authenticated by the mediator. Because how do you prove that this was a settlement made under a mediated settlement agreement or a mediation process? See, there are various mechanisms under which Article 4 of the Singapore Conventions stipulate that how you can prove that the outcome or the settlement was made under a mediation process. So the first process, the first requirement is to show that it was signed by the parties and it was authenticated by the mediator. And of course, if the mediator has not signed it, or the parties, only the parties have signed it, then the Singapore Convention stipulates that it can be endorsed by the institution which has conducted or administered the mediation. But to make sure that the first formality itself is complied, the APCAM rules stipulate that it shall be authenticated by the mediator himself. And as I said earlier, under the ARB-MEDA protocol, under the case management, once the mediated settlement agreement is made, it shall be signed and by the parties and the mediator, and it shall be submitted to APCAM, and it is not submitted to the parties, it is submitted back to APCAM under Rule 12.4. And on completion, of course, the mediator will have to submit a completion report to APCAM on the status of the mediation process and what was the outcome of the mediation. He'll have to submit a mediation completion report. And as per the case management process, after the mediation is completed, the mediator may invite the parties or the counsels or the advisors who has participated in mediation to submit a feedback form or a mediation evaluation form under Rule 15. See, this is a crucial mechanism under the APCAM rules, because the certification or the accreditation of the mediator will be determined under the feedback digest that is made by the reviewer of each mediator. So the feedback form and the evaluation form will be submitted to the reviewer of APCAM, and periodically the reviewer will update the feedback digest, and that will be uploaded in the website of APCAM, so that any party who wants to appoint that mediator can go through the feedback digest of the mediator to know what the parties have how the parties have evaluated or how the parties have found the mediator to be good in the mediation process. So a feedback digest and an evaluation digest will be made, and for that every mediator on the conclusion of mediation will have to invite the parties to complete a feedback form or an evaluation form. And if you look at the role of APCAM at the conclusion of mediation, after receiving the completion report from the mediator, APCAM will issue a mediation status report to the parties. So even if the mediation ended up in a failure, there was no resolution, APCAM can still issue a mediation status report to the parties, how the mediation got completed. So this mediation status report, it can be given even if the case cannot be commenced due to the non-appearance of a party. APCAM will issue a mediation non-starter certificate, and this is also a key certificate which shows that a party has initiated mediation but could not commence or complete mediation because of the non-appearance of the other side. So this, in many jurisdictions, this non-starter certificate is of key importance, because when they go to court, in many jurisdictions, there are the parties are directed to go for mediation again by the court. So the party can submit the non-starter certificate to say that I had actually initiated mediation, but the party, since the other side did not come forward for a resolution, we could not commence mediation. So this non-starter certificate will give an indication to the court that this party had attempted mediation, but it was not completed, or it cannot be commenced because of a non-cooperation from the other side. So this mediation certificate is also given by APCAM. And of course, in an ARB-MEDA procedure, the mediation status report will be sent to the arbitral tribunal or the emergency arbitrator who has stayed the initial arbitration process under Rule 24(4). And if the dispute is not resolved by mediation, then APCAM will advise the arbitral tribunal to continue with the arbitration process so that they can proceed with arbitration. And if the parties have settled the dispute through mediation, then APCAM will give the mediation status report to the arbitrator saying that the dispute has been resolved, so that the arbitrator can either record the settlement terms in the award and make it as an arbitral award on agreed terms, or they can close the mediation arbitration process and confirm if the parties are happy with the settlement agreement, the arbitrator can close the arbitration process. So this report is also given under the APCAM rules. So if you look at the entire process of case management, it makes sure that the parties and the neutrals, and of course the institution, can go through the entire mediation process in a guided format, so that the process is made more efficient, professional, and also it makes sure that there is no infirmity on the final MSA that is made out of this case management process. So basically, the entire case management is done to make sure that the entire cross-border dispute is managed by the parties, managed by the mediator, and of course supervised by the institution in the best possible manner, so that the ultimate outcome that they get is not refused and enforcement. Because what happens if the case management is not effectively followed is, even though the parties have come out with a resolution maybe with a very hard negotiation and mediation process, ultimately, if they are not able to enforce it under the Singapore Convention, the entire time and the efforts made by them is lost. So the APCAM rules make sure that the mediation process, once they come for mediation and the mediation is completed, then it ends up in an effective manner, and the result of the mediation, the settlement agreement, is properly enforced, even if they take it to any courts anywhere in the world. So that is the case management that we have designed under APCAM. So I hope the mediators who are empaneled with APCAM, the mediators who are looking forward to empanel with APCAM, will have a very comfortable and efficient way of case management under the APCAM rules. Any questions?
Sir, I had another question.
Yes, Anil.
So you covered very nicely all the grounds for rejection under the Singapore Convention, but there is another ground that has been used very often in arbitration cases, that is the public policy ground for refusal. So can that be addressed in any way by the case management process?
No, see, basically, one of the conditions of the Singapore Convention is the dispute should be a mediatable dispute under the law. So if the parties have assigned a particular law for their agreement or a contract, then the dispute should be mediatable under that law. So fundamentally, the Singapore Convention does not talk about a public policy, but the Singapore Convention is basically a guideline that has to be reinforced by a national law. So every country will have to have a law under which the settlement agreement will be enforced. Singapore Convention is only a guideline or a framework under which the enforcement will be made. So suppose under a national law, they have put up one more condition, that an enforcement will be refused if the settlement terms are against the public policy of that country. Then that will be a ground for refusal in that particular country. See, but the difference is, no settlement agreement can be set aside by a national court when it goes for enforcement, because they can only refuse enforcement. The settlement agreement will be still in force, and they can enforce it in another country where this public policy issue is not available in that country if the other party have got assets in that country, because we are talking about cross-border disputes. So a company or a organization will have, suppose they have assets in different parts. They can go and enforce it in another country where this particular aspect is not coming under the public policy of that country, or if the national law of that country does not have a public policy issue at all. I hope it's clear, Inam?
Yes, sir. From what you said, I have another question. So you said that some subject matters may not be mediatable under national laws. So in that case, could consent awards be a workaround to that? That instead of formulating it as a mediated settlement, we formulate it as a consent award?
No, basically, Inam, if you look at the enforceability of a mediated settlement agreement and the enforceability of an arbitral award under the New York Convention, what we could analyze under the Singapore Convention is, if a settlement agreement is made effectively and efficiently, then a settlement agreement is more easily enforceable rather than an arbitral award, because under the New York Convention there are more stipulations for enforcement of an arbitral award, and there are less stipulation for an enforcement of a settlement agreement. So to convert it to an arbitral award on agreed terms, in certain circumstances it will create more hurdles rather than making it easier.
Anil,
yeah. Yes,
advice. We are running out of time actually now.
Yeah, okay. I'll take one more question from Irfan because he has raised his hand, and then we'll stop this. Yes, Irfan?
Great.
Sir, very humble greeting, sir, and congratulations on the event. Sir, I have a doubt with respect to the AMA clause, sir. Now, the Singapore Convention says that whenever New York Convention is applicable, it is not applicable. So, with respect to AMA, how to get it under the Singapore Convention, sir?
No, you mean the mediation arbitration clause?
Yes, sir. Yes, sir.
The Singapore Convention does not guide how the mediation clause should be drafted or how the mediation agreement should be drafted. See, under the AMA clause, once the arbitration is stayed and the parties are sent to mediation, it is entirely a voluntary process that the parties have agreed. Because under the contract, they are stipulating that in case they commence arbitration and the parties have agreed to stay the arbitration process and take it for mediation, then under the Singapore Convention, the only requirement is the party should voluntarily take up mediation, and the mediation process, the party should voluntarily participate, and the ultimate resolution should be made by the parties. And the mediator should not have a power to impose any decision. In AMA protocol also, the mediator is not imposing any resolution on the parties. They have voluntarily come out with a resolution, and the decision that is taken is passed on to the arbitral tribunal to only mention that if they want, they can close the arbitration, or they can continue and make it as an award on agreed terms. So that has absolutely no restriction or no prevention under the Singapore Convention. It's perfectly according to the Singapore Convention.
Sir, I had the doubt regarding initiation, sir. Now, when we are initiating arbitration, particularly cross-border, and then it is under New York Convention generally, which we try to do.
See, when you invoke arbitration or mediation, there is no relevance to Singapore Convention or New York Convention. Only at the time of enforcement, these conventions come into place. Otherwise, you can start mediation or you can start arbitration without any UN instruments. It is an agreement between the parties. So at the time of starting a cross-border arbitration, there is no relevance for New York Convention, because or if you start a cross-border mediation, there is no relevance for Singapore Convention. These two conventions are applicable only for enforcement. So commencement doesn't relate to any convention.
Okay, sir. Thank you, sir. Sir, with one more doubt I had with respect to the time period. Like after 4 months, you said that the mediation stops. So, what will be the consequence after the 4 months, sir, under
No,
the APCAM case
of
management?
course, there is some discretion given to the APCAM Secretariat to talk with the parties and have a separate agreement to continue with that process. Because if in some cases in cross-border mediation, it may be required that they're genuinely participating in mediation, but the time is too short to complete the process. Then, of course, they can the rules stipulate that the parties, with the assistance of the administrator of APCAM, they can extend the time even beyond 4 months. I think the time is running out, and Fami has already said it is running out. So I'm giving back to Iram.
Thank you so much.
Yeah, thank you so much, sir, for a very nice session on the case management and elaborating it with the sync of Singapore Convention. Because we all understand that what mediation is and what arbitration is, but the most important thing is how to conduct arbitration and mediation within the process. That is something which is very important for all of us, because many of us are not having the better understanding for the case management. So thank you for this technical session on the case management, and for all the audience and for all the participants in this seminar. I would like to say thanks to all of you to make this this event successful. And we will be coming for the next lecture on 3rd of September, that is on the investment dispute. And that session will be, delivered to us by Professor Rajesh Sharma. And so 3rd September will be the next date for this. So I will be seeking your collaboration and your support for the lecture series. This is something which is for all of you. So thank you so much for everyone, for the APCAM board member, for the APCAM family and chairman, and all the participants. Thank you so much.